All right, thank you, and hello, everyone. Welcome to Burner Prudenti Law's webinar today on estate planning. We are in a new year, 2024. So while most of the issues about estate planning are similar, or if not the same as last year, there are some changes that are taking place, and we're going to discuss those today. I'm just going to give it another minute in case anybody's had trouble getting on. And we'll get started, actually another 2 minutes, and we'll get started at that time. Thank you. Okay, so as promised, we're going to get started. Thank you for joining today. This is Burner Prudenti Law's estate planning basics topic. So basically, we're going to be talking about what documents it is that you need during life and after death that you can make sure you're cared for as well as your loved ones. I want to start by telling you that Burner Prudenti Law is a women-owned law firm with 4 offices from East Hampton all the way into Manhattan. We have, in our 4 offices, we handle estate planning, trust and estates administration, elder law, and real estate. And the things we're going to talk about today are going to touch a little bit on each of those topics. So thank you again for joining us, and let's get started. So first, I'm going to talk about what we call advance directives. These are documents mostly relating to your health care that have to do with how you should be taken care of if you are unable to communicate your wishes with a physician or other medical staff. So they're called advance directives because you sign them in advance of needing them. The most well-known and the most prevalent is the healthcare proxy. This says who makes medical decisions for you if you're unable to make them for yourselves. You would name one person at a time, so you can't have, if you have 2 children, for example, or 2 siblings, you cannot name them to have equal authority. You must name one with the other as a successor or backup. You have to put that person's name, address, and contact number. And you need to sign this document in front of 2 witnesses who are over the age of 18, who are not otherwise named in the document, as your witnesses to sign that document. You do not need a notary, you don't need a lawyer, you don't need a doctor. These are documents that you can sign with any 2 witnesses, although they do have to witness you signing the document. A lot of people will go on the New York State Department of Health website and find a healthcare proxy form, which comes with instructions for how to fill that form out in order to get this document completed. Often when doing an estate plan with a lawyer, this is one of the documents that would be included in that plan. Although, again, it's not necessary to have a lawyer to do this document. You want to specifically state whether your agent, the person you're naming to make medical decisions for you, has the right to make end-of-life decisions regarding all things, including artificial nutrition and hydration, withholding and withdrawing treatments. You want to give the authority in that document. You also can put a limitation on the duration of that document. So you can say, this is my healthcare proxy, but only for the next 6 months, or this is my healthcare proxy indefinitely. You can state that right there in the document. You can also put if you're an organ or tissue donor on that document. A copy is as good as an original, so you could make 10 copies once you sign it and hand it out to the doctors, or if you go in for a procedure, give a copy to the agent you've named. But it's only in effect if you're incapacitated as deemed by a doctor. Along with that document, we often do what's called a living will. A living will is a document that talks about your wishes regarding artificial nutrition, hydration, and other end-of-life treatments, and whether or not you give your agent, your surrogate decision maker, the authority to make those decisions on your behalf. And it, in general, shows the intention behind how you would want your treatment to go if you become unable to speak and unable to communicate those wishes, either because of being unconscious or some other type of incapacity. However, if you have capacity and you're able to communicate your wishes, you can override either of these documents. It also is signed in the presence of 2 witnesses and does not need a doctor or a lawyer or any other professional. It does not need a notary as well, just those 2 witnesses. A lot of times people will say in this document, if I'm in an irreversible state with no reasonable expectation of recovery, that I do or I don't authorize my agent to withhold or withdraw treatment. That way we're leaving, I like to write it in a way where we're leaving the decision in the hands of the surrogate decision maker that you've chosen. Often we have people also sign a HIPAA release form. HIPAA is the law that governs your healthcare privacy, and if you sign a release form, you're allowing specific physicians, medical records, etc., to release information to the individuals that you need. Again, this document can have a duration, so you can say for the next 6 months or for the next month or whatever it may be. But this one does not require any witnesses. So you don't need a doctor, you don't need a lawyer, you don't need a notary, but you also don't need witnesses. You have to sign and date this document. And this is a way to give information about your medical care to other individuals that are not named as your healthcare proxy, or also if you have mental capacity, but you want someone else to have this information, the release allows that to have information. So take, for example, an individual who names their one child as their healthcare proxy. If they still have their own mental capacity, the one child isn't their healthcare agent acting because they have been deemed incapacitated. Therefore, the HIPAA release would allow that one child release of medical records if it was appropriate and if it was what the parent wanted. So that's often the use of that HIPAA release document. Along with the healthcare documents, I also have people do a disposition of remains document that specifically says who is the person that is responsible for the determining what's going to happen with your remains after death, with your physical body, and what should happen. That can be a very detailed document, or it could be more vague. Most importantly, you are appointing an agent for this purpose. You're appointing who is in charge of that sign-off. And if you specifically want to be cremated, I suggest that the documents say, I wish to be cremated. That way there's no question about those being your wishes. And if there's any other wishes you have regarding your remains, it would go into this document as well. I've also had some clients who've said that they leave it in the discretion of the agent that they've named. So again, going back to the agent being named being the most important. Moving on from your health and your physical body, I'm going to move to finances. So in New York, we have a New York power of attorney. Now, you might have seen the terms durable power of attorney. That means that the document is in effect now when you sign it, and if you should become incapacitated, so it survives that duration. Or you might have seen the term short form power of attorney. A short form power of attorney is often the same document as any other power of attorney. I will add that in New York, all powers of attorney are durable unless they say they are not. So in the past, the form was actually titled durable power of attorney, but the standard state form now does not use the word durable. However, in the body of the document, it likely states that it's a durable document. In my time as an attorney, I'm not sure that I've come across a power of attorney that was not durable or intentionally not durable. A power of attorney has to do with your financial life. I often say it's the business of your life. So are you looking for someone to pay your rent, pay your mortgage? They're using your funds, they're signing your name with an indication that they're signing off with your authority based on this document, but they are taking care of those day-to-day things and the larger things. So it could be running a business, signing documents related to that business. It could be hiring home care attendants to assist you at home. It could be signing a lease, paying the mortgage, refinancing, whatever the business things of your life are to make it run. That's often what a power of attorney will do for you. I also think of it as any of those times that you have to call somewhere and authorize who you are. So if you call the credit card company and you have to answer those few security questions to show that you're authorized on your own behalf, a power of attorney would have to be on file for someone else to act in your behalf in that case. And so they would call up and not pretend to be you, but indicate that they are the power of attorney and that the power of attorney was on file with that specific institution, and therefore they have the authority to act on your behalf. Unlike the other documents I've discussed, a few things. One, it's in effect for the most part, whether you're incapacitated or not. So once you sign a power of attorney, you sign it. You don't need a lawyer, although you might want to have one to discuss the implications of the document. But you do need a notary on this one, and you also need another witness. And so in order for that document to be effective and for that individual to be able to go forth and act on your behalf, you sign it in front of a notary and another witness. And then the agent, the person that you're naming to act, they will then sign it as well in front of a notary and accept that position. Once those two things have happened, that document has to go to whatever institution or organization you want to honor it. So if I want the bank to accept the fact that this person is my agent on a checking account, then I need to present a copy or the original in some cases of that document to the bank so they could send it to their legal department so that they can determine whether or not it's a valid document and then authorize that individual to act on my behalf. Until all of those steps have happened, that power of attorney, that individual is not able to act with regard to that account. Now, you might put it on file with your checking account, but maybe you didn't tell your insurance company that you have a power of attorney, and that's okay. Well, if there becomes an issue where an insurance claim has to be put in and that person calls and says, I'm the power of attorney and I'm calling on this individual's behalf, well, the company is going to say, we need to see a copy of that document and we need to put it through our legal department. And once that's done, we'll authorize you to act. Now, this could be something that takes a few minutes, a few hours, or a few days, hopefully not a few weeks. But that is the process that has to happen with everyone that you want to accept that document. If you're selling a house on behalf of someone, the title company needs to accept that document, etc. So a power of attorney is only as good as what the terms of it say. So I might have a document that I signed, I had the proper notary and witness, my agent signed, they had the proper notary, they are now power of attorney under my name. However, what can they do? Well, every power of attorney is different, and they're not all created equal, and the specific powers listed in the document and given by the document are what the powers are that you have. So I've had situations where someone named someone that they weren't particularly close with, but a very helpful individual. And the only thing they had the power over was helping them pay the bills, the regular expenses, writing checks, etc. But they didn't have the power to sell real estate. They didn't have the power to sign contracts on the individual's behalf and all the other things that we might put into a power of attorney if someone has a deeper level of faith or a closer relationship with the individual they're naming. So that when I said earlier that you may want an attorney to sign a power of attorney, it's because it really is a big question about what access to your life and your assets are you giving another person, and how far do you want to go? How much power do you want to give them? And if you hold back on certain powers, what are the potential downsides? If I don't give my agent power to do a certain thing, what could possibly happen down the line? And so it's important to speak with an attorney to discuss the pros and cons of giving or withholding certain powers to make sure that you're comfortable with the document you signed, you're comfortable that you haven't given away more than you think is appropriate in terms of power. But at the same time, that you understand that by holding back certain things, that might have a certain consequence down the line, and can you live with that consequence, right? A lawyer should be there to educate you, to tell you the pros and the cons, and then to help you use those pros and cons to make a decision that's right for you. because every person listening today is going to have a different threshold of where they feel comfortable giving authorities. Everybody here is also potentially naming someone different or a different level of relationship as their agent. For some people, they're naming their spouse and their child that they trust very much, and that feels very comfortable and they're okay giving a lot of power. For some people, they're naming their spouse and their children and they don't feel comfortable giving them a lot of power, and so they want to hold back there. And then for others, it might be a more distant relative or a more distant relationship, a friend, a potential employee in certain circumstances, and then we want to be careful on what power we're giving. As long as you have your mental capacity, you can revoke a power of attorney. So if it's in effect now, but then I decide I don't want that person to be my agent anymore, or they decide they don't want to be agent anymore, I can appoint a new power of attorney with a new document. I like people to avoid having all sorts of power of attorneys floating around out there, because if you do become incapacitated, you don't want there to be an ambiguity as to who you wanted to be your agent. So if you're switching agents and that document has already been given out places, you might want to do a proper revocation, revoke the old power of attorney to make it clear that what your new wishes are. Again, these are things that an attorney can counsel you through. If you have an old power of attorney and you named an individual and that person's no longer living or doesn't want to act anymore or moved out of state, and no one's ever seen that document except for you and maybe the individual who signed it, you might not need to go through the full process of revocation. So it's going to depend on each individual circumstance. In 2021, June 13th of 2021, a new power of attorney went into effect. The most important thing to remember about that is if you have a power of attorney from before that date, June 13th of 2021, it isn't necessarily a problem. It could very well still be a fully valid power of attorney and do all the things you want it to. What I would urge you to do is if you have a power of attorney from before June 13th of 2021, you should have it reviewed by your attorney to make sure that it still accomplishes the things you want it to accomplish and that there isn't maybe a different way that you could do it. The changes that were made in 2021 were to form as well as to substance. So you just want to make sure that you have the right document for you at this point in time. If your power of attorney is from before 2010, you should definitely get a new one. The power of attorney law changed in 2009, slight tweaks in 2010, and then not again until 2021. But prior to 2010, or certainly 2009, I would say you should be having a new document. Not because it is not valid, but because the way we wrote those documents back then and the way the law was structured, things have changed quite a bit, and it may not do what you want it to anymore. It may not have all of the specific and individual powers that you expected it to have. So you want to be careful there. Now we're going to move on to a will. So we've talked about the life documents, we've talked about healthcare, we've talked about the disposition of remains for your physical body at death, we've talked about the power of attorney, and now we're going to talk about wills. And once we talk about wills, we're going to talk about trusts. So I will keep moving there. So what is a will? A will is a document that says how you want your assets distributed at the time of your death. It should say who you want to be in charge of doing that distribution. That's called the executor, and lay out other certain rules for how your estate should be handled. So simply you could say, I name my spouse as my executor, my spouse gets 100% of my estate, and things are very simple. Or you may have things a little more complicated that includes, other family members or not your spouse's executor, etc. All wills are for assets that are in your sole name with no beneficiary. So for example, if you have a retirement account, an IRA, and you have a named beneficiary on that account, that is going to your named beneficiary regardless of what your will says. So if everything says, if the IRA says it's going to child A and the will says it's going to child B, child A is going to get that retirement account because that's what's on file with the institution. Again, the will is only going to control assets in your sole name with no beneficiary. So if you're the only person on the deed to your house, if you're the only person on the shares to your co-op, if you're the only person on your bank account, your brokerage account, and you have not named a beneficiary, these are all the things that will go through the probate of your will. So very often an estate has certain assets that are probate assets and certain assets that are non-probate assets. A really common misconception is that if you have a good will, or if you have a will that covers all the bases, that it doesn't have to go through probate, and that is wrong. That is the number one misconception that I come across. All wills go to probate when there's assets in someone's sole name with no beneficiary. And if it doesn't go to probate, it's just a bunch of paper. A will says who the executor will be. However, all it's doing is it's nominating an executor. So I'm signing my will and I'm saying, when I die, this is who I want to be in charge of my estate. But that person is not actually in charge of my estate until my will goes through the process of probate. And when probate is completed, the court determines that that person is appropriate and makes them the executor. And it's only then with that court document that says they're the executor that they can go ahead and collect the bank accounts, take in the money, sell the house, whatever has to be done. So it's really important to remember that all wills go through probate. Now, why is that so important? Well, what does probate look like, right? What's the big deal? We hear people on TV, you hear things all the time. You have to avoid probate. You have to avoid probate. And for a lot of people, that might be true, but for some, it might not be. So the first thing to know about probate is it is a process by which your original last will and testament, the original, the one, they call it a wet ink copy, the one that you put pen to paper on, that original will is brought to the court with a petition asking that the will be admitted to probate, asking the court to approve that will, and asking the court to appoint your executor. This is usually done by an attorney, although it doesn't have to be, and it's usually an attorney hired by that nominated executor. Once that will goes in for probate, the court wants to see that your next of kin were all notified. So if you have a spouse and children, or just a spouse, then your spouse and children are the only people that require notification, and that might be fairly simple. However, what if you're disinheriting one of those children and now they have to get notice of your will that they're left out of? And not only are they getting notice of the will, but they see on the probate petition that the estate's worth over $500,000. Well, they might very well want to contest that will to try and get some of the money or try to get paid off or whatever it may be. So if you're disinheriting one of those natural heirs, you want to be careful. Also, what if you're a person who doesn't know who your heirs are? Very regularly, I meet with people and they think they have a simple situation because they don't have any family, but that's where probate gets most difficult, right? So what if I'm not married, I don't have children, my parents are deceased, I never had siblings, I'm an only child, and maybe I have cousins somewhere, but my parents were from other countries and I don't really know where any family is. Well, in that case, in order to probate your will, we would have to do a genealogy search to try and find those individuals. Then if we can't find those individuals, after convincing the court that we've tried and we've tried and we've tried, then the court appoints what's called a guardian ad litem, and a lawyer, a person, to represent the interests of these unknown people, which is all just more time and delay. So these are the kinds of reasons why we'd want to avoid probate. So we don't know who our next of kin are. If we're looking to disinherit our natural next of kin and we think they're going to be mad about it, contest and hold things up. If we have property in multiple states, so say I'm a New York resident who has a cabin in Pennsylvania, a small hunting cabin in Pennsylvania, or whatever it is people do. Well, you would have to probate your will here in New York, and also in Pennsylvania where you own that property. Because anywhere where you own dirt, anywhere where you own real property, your will has to go through probate. So you can see that the probate process can be very difficult if you fall into one of these categories. I would add to those categories if you have a disabled beneficiary or if you have minor beneficiaries, that will again create a situation where the court will appoint a guardian ad litem, and you might well want to avoid probate in those circumstances. So as a recap, you would likely want to avoid probate if you have unknown next of kin, you're disinheriting next of kin, you have property in multiple states, you have a disabled beneficiary, or you have a minor beneficiary. Also, as we're going to talk about trusts in a minute, if you are leaving things behind so that after your death they stay in trust for a beneficiary, you might also want to avoid probate, because otherwise that trust will forever be under the court. And anytime a trustee changes or anything changes with the trust, they have to go back to court. So you might want to avoid court in that circumstance. Perhaps the biggest reason people like to avoid probate, which I didn't even mention, is delay. And that's really based on location. My understanding is that colleagues of mine who are maybe in a more rural area of the state, upstate, the western part of the state, that probate is not so difficult or doesn't take so much time. However, downstate, Westchester, Manhattan, any of the 5 boroughs, Long Island, there is a few months of delay. And while the estate is in probate, everything's frozen. So some people like to avoid for that reason too. So how do you avoid probate? So remember, I said all wills are for assets in your sole name with no beneficiary. So how do we avoid probate? We make sure things aren't in your sole name or they have a beneficiary. So on an account like a retirement account, you'll likely name a beneficiary. You might also name a joint owner on certain assets. You might have a checking account that you make joint with a child or with your spouse, but that joint ownership would avoid probate. Or you might create a trust. If I create a trust, and I'm going to go through what a trust is, but if I create a trust and then the owner of my asset is that trust, then it's no longer in my sole name, and that's how we avoid probate. So very simply, if I create a trust and then I sign a deed putting Britt Burner's house into the Britt Burner Trust, then when I die, that house is owned by the Britt Burner Trust. It's not in my sole name. It doesn't go through probate, but the trust itself, the document, determines how that asset is distributed, where it goes, what happens with it. Do I direct that it has to be sold and divided up? Do I direct that the whole house goes to someone? Do I say these 2 people are going to share the house? What are the terms? And so we put that all right into the trust document, just like we would in the will document. Unlike a will that only controls things after your death, a trust that is created, a living trust, you might have heard the term revocable trust, asset management trust. These are trusts that own things while you're alive as well. So it's not enough to just draft up the document and sign it like with a will. You have to also put things into it. Because if I die and my house was never changed into the name of my trust, or my co-op was never changed into the name of my trust, it will have to go through probate. Even if my will just says put everything in my trust, it still has to go through probate so that everything could be poured into the trust and be distributed. So you want to be careful not to just create the document, but also then to fund the trust property, to put things into it. With a bank account, you would go to the bank and give them a copy of the trust or a certification of trust, and they would change the title on the account. With a deed, you change with a house, you change the name on the deed. With the co-op, you would change the names on the share certificate. So it's going to depend on the type of asset, what has to be done. Now, this type of funding of a trust is probably something, again, that you should have an attorney assist you with, not just the terms of the trust document, but also understanding what should go into the trust, what shouldn't go into the trust, and what's going to happen. That's really important last step to this process. I'm going to talk about estate taxes briefly, just so you know the new numbers, because we're at the beginning of 2024 now. So on the federal side, if you died this year with less than $13.61 million, you will not have a taxable estate for the federal government. So that's double for spouses. So $13.61 million per individual. Now, that law is going to sunset. What does that mean? So back when Donald Trump was our president, he signed the Tax Cut and Jobs Act, and that put this graduated higher exemption level into place. But that same law says that for those who die as of January 1, 2026, that law will sunset and it will be back down with indexes for inflation. Most believe it will be between $6 and $7 million. So that 13.61 that you can give now at death without any estate tax is going to go down drastically in 2026. Now, on the federal side, that is a lifetime amount. So that means if I give you $5 million today, and then when I die, I give you $10 million, that's a $15 million gift over the course of my lifetime and at death, and therefore it would trigger a tax because it's a total of $15 million being given away. However, if I give less than $18,000 a year per person, so if I gave everybody on this Zoom today $18,000, I don't have to report that with the IRS, and it does not go against my lifetime exemption. But if I gave you all $100,000, then I would have to report to the IRS that $82,000 of a taxable gift was given to every person on this Zoom. And then that would just get filed away so that when I died, they'd count it all up to determine my lifetime exemption. In New York, we have a lower exemption. It's 6.94 million. So if you die with less than 6.94 million, no estate taxes. If you have over 6.94 million, then once you hit 105% of that, which is about 7,287,000, then you fall off the cliff. That's the terminology they use. If you're 105% of the exemption amount, you fall off the cliff, meaning that you're taxed from $1. There's no exemption. Now, between 100% and 105%, you're only taxed on that overage, the little amount that you've gone over the 6.94 million. But once you hit that cliff amount, you fall off and you pay tax from $1. So you can see how it's a very gradual, there's no tax, no tax, no tax. Then all of a sudden it goes up a little bit with the up to 105%. And then it just, well, you fall off the cliff, but the taxes skyrocket. So you want to be very careful to do proper planning. Now, unlike the federal government in New York, it's only what's in your name at your death. It does not include lifetime gifts unless they were made within 3 years of dying. So you want to die and then, you want to give a gift and then live for 3 or more years so that it's outside of your taxable estate. So there's a lot of planning that can be done if you find yourself in the position where you have between, let's say, 5 million and 12 million or 5 million and up, where there's some tax planning that we'll do. And there's certainly tax planning we'll do at any amount up from there, but where we could even fully eliminate taxes based on the situation, depending on how large your estate is and what it's comprised of. We often will do what's called a disclaimer to charity. So let's say I am writing my documents and I have an $8 million estate. I say, okay, you know what? Everything over the exemption amount, so the difference between 694 and 8 million, I'm going to give that all to charity when I die, if my beneficiaries want to. So I pick the charity right now, and I put in the provision that this is where it goes if they say that's what they want. And then if they trigger that upon my death, that overage goes to the charity, they're back down under the exemption and there's no tax again. And they've gotten to give to one of my favorite charities. So that's something that we do when we're doing tax planning for people who are just over the cliff. If you are well over the gift, that's a whole other subject for another day, but you should really be getting personalized advice about how to save your estate taxes. Another thing I want to point out in the tax realm is that for capital gains tax purposes, you get a full step up at your date of death. So what does that mean? So let's say I bought a stock and it was $1. And 20 years later, that stock is trading at $200. Well, I have a $199 gain in that stock. And if I sell it while I'm alive, I'm going to pay a capital gains tax on that $199 per stock. But if I die owning that amount, then once I die, it gets what's called a step up in basis. So that means that it goes from a $1 level to determine the taxes to my date of death value, which might be the $200. And if I turn around and sell it at $200, there's no gain and no tax. So if you hear of people who are holding on to property, because this goes the same for real property, a house, etc., condo, co-op, if you know someone who's hanging on to real property because they're worried about capital gains taxes, that's what they're worried about. They're thinking, if I can hold on to this until I die, I've saved an enormous amount for my family on taxes. However, if I sell it while I'm alive, I'm paying a capital gains tax based on my own purchase price. Another thing I want to point out about taxes is regarding retirement accounts. So let's say you have $100,000 in an IRA. And when you die, it goes to someone other than your spouse. And there's certain exemptions, the spouse is one of them, but let's say it goes to your daughter. Well, your daughter is then going to have to take that money out and it will have to be taxed, right? Because it's an IRA, unless it's a Roth, but assuming it's a traditional IRA, you have not paid the income tax on that money. So she will need to pay the income tax. She will be forced to take required minimum distributions on that $100,000 IRA every year until she liquidates the whole thing. And she has to liquidate the whole thing within 10 years. So if she liquidates it all in year 10, it might grow tax deferred every year, but then she's taking a full taxable payout at the end. Or if she takes it a little at a time, she's extending her exposure to taxes over time. So again, that's something that's going to need some counseling, but something to keep in the back of your head about who are the beneficiaries of your retirement asset, the tax deferred retirement asset. The last thing I want to talk about with regard to trusts is when you maybe have a family property. So say you have a vacation home or it was grandma's home and everybody loves it and everybody wants it. Nobody wants to be fully in charge of it, but they know they want to keep it in the family. Creating a trust that says what happens at your death and who's in charge of the property and how the expenses should be paid, as detailed as we can be about what might have to happen with that document or with that trust and the house, the better it is, because with less ambiguity, there's less fighting. So you might say everybody gets to use it 1 week out of the year exclusively without anyone else there, but they can share it the other times. And this individual is who's in charge and is going to pay the taxes and pay for the maintenance and the upkeep, and they get a fee for managing it. We can lay all that out so that it's very clear what your intentions are and that there isn't infighting in the family after your death about this beloved property. So that's really important planning for our clients, especially our clients who have these vacation homes, these second homes, or their first home in a location that some would want to make their own second home. I'm going to pause now because I think there might be some questions. For those of you who cannot join us any longer, thank you so much for joining us at Burner Prudenti Law today. It was very nice speaking to you, and we hope you come back for our next webinar. So thank you. For everyone else, I'm going to answer some questions. So please, at the bottom of the screen, you'll see there is a Q&A. So please feel free to put your questions into the Q&A. Someone asked if you can put a co-op property into a revocable trust to avoid probate. You can and should, as long as the co-op allows you to do so, because anything we do with a co-op, you have to do through the co-op and the board and the managing agent. So if they allow it, which most do for revocable trust these days, then that's fine. Also realize if you have a mortgage on that property, your original stock and lease, because a co-op is ownership of stock in a corporation and a lease for the unit, that original stock and lease might be with the bank or institution that holds the mortgage, in which case we also need to get their sign off and okay on the transfer of the co-op into the revocable trust. So we do that very often, but yes, that can be done. Someone asked if we practice in New Jersey. We do not practice in New Jersey, but I can recommend that if you're looking for an attorney, you can email us, and if we have a good referral, we can send it over, info@burnerlaw.com, or you could always go to the National Academy of Elder Law Attorneys website and look, we put in a zip code and I'll tell you an attorney near you. IRA accounts with beneficiaries do not go into a trust. So this person asked if they go into a trust. They do not, because that would be a taxable distribution. They remain with the beneficiaries on them because someone has to pay that income tax. So you want to make sure that it stays as is while you're alive and pays out to beneficiaries. There are certain types of trusts that can be the beneficiaries of retirement accounts, and in certain circumstances that makes sense. But you want to make sure that you're being advised by a lawyer who understands those rules and understands properly how to draft the trust, because it can greatly, trust that's not drafted properly to accept those assets could have very large tax implications because it could force a sooner payout. And so if your beneficiary is forced to take a lump sum payout of that retirement account, they're going to pay all the income tax up front. So you should only be changing beneficiaries of your retirement to be a trust if you're doing so under the advice and counsel of an attorney that has drafted the trust to properly accept retirement accounts. Someone asked if we get access to the recording. We usually put them on our YouTube page and on our website as well. Someone asked about the ramifications of putting their son on their Schwab account. I mean, I wouldn't generally recommend that you name someone else as a joint owner on your account other than maybe a spouse, except in limited circumstances. But one of the concerns I think would be that if someone is joint on your account and they have creditors that are coming after them, they now have access to your money as well because you've made that person joint and they own that account just like you do. So you want to be very careful when you're making someone joint on an asset that you're not exposing your asset to creditors of that individual. The difference between a revocable and irrevocable trust. So a revocable trust is one in which you can do anything you want. You can change it, etc. I would say that an irrevocable trust is a trust that limits you in some way in order to gain some kind of a benefit. So there are trusts that are irrevocable for Medicaid asset protection purposes. So you can't be the trustee and you don't have access to the funds, but it protects those assets for Medicaid eligibility purposes. There are certain irrevocable trusts that are done for estate tax planning purposes. Again, your loss of control and use of the assets will often get you some sort of a benefit for planning. It's asking what guidance you have if there's not an obvious person to designate as power of attorney or executors for wills or trusts. So it's hard for me to give a large answer to a wide audience about that. But what I will say is you should be discussing with your attorney where there are certain professionals that can be designated in certain positions, be it a lawyer or some other professional, and figuring out how your estate should be distributed. And again, that's really going to depend on what the assets are. Is it real estate? Is it bank accounts, et cetera? And then how it should be distributed. If the co-op doesn't allow you to put the co-op into a revocable trust, is there anything else you can do? And I'm assuming this person means to avoid probate. You could have a joint owner with rights of survivorship, if that's something you feel comfortable with. Again, probate is for every asset in your sole name with no beneficiary. So if you have a joint owner that has rights of survivorship, that's not in your sole name, and therefore it won't go through probate. Someone asked about they go between New York and Florida. Where do you create the trust? You are supposed to create your estate plan in the state in which you are a resident. So if you are a New York State resident, they look at where you file your estate taxes. Where you file your income taxes, where you have your driver's license, where you're registered to vote. All these different things are indicative of where you are a primary resident, but your place of primary residence is where you should create your estate planning documents. This person's asking if there's any effect on capital gains tax when you put real estate in a trust. Not when you do a revocable trust, which is what I discussed today, or certain other trusts. It just depends, and depends on the purpose. But if you're creating a revocable trust merely for the purpose of avoiding probate, then no, the capital gains are the same as if it's in your own name. Does POD or TOD on a brokerage or bank account avoid probate? Yes, because remember, probate is in your sole name with no beneficiary. So if you have a payable on death or a transfer on death, those are beneficiary designations. And so the accounts will go to that individual and it will avoid probate. All right, I think we answered all the questions. Well, thank you so much for joining us today. And I hope you all stay warm and we'll see you soon. Thanks.